is Title VI, A Tool for Environmental Justice. My name is Gormley. I'm a staff attorney at Earthjustice. For anyone who's not familiar with Earthjustice, we sometimes call ourselves a nonprofit environmental law firm. We're a nonprofit. We do all of our work pro bono, but we do have a client model where we represent community groups and individuals and other types of nonprofit organizations, primarily in litigation, but in a wide range of legal matters with an environmental focus. And one of the areas that we work in is Title VI. So I am going to be the moderator of our panel today. And we're very fortunate to be joined by a panel of the real experts on Title VI. And so I'm going to do as little talking as possible and let our panelists talk and leave lots of room for discussion and questions at the end. But just to say a little bit about what we're hoping to do today. We're going to explore administrative complaints under Title VI of the Civil Rights Act of 1964, and we're going to try to evaluate them as a tool for pursuing environmental justice. So we want to try to explore how effective are they as tools for environmental justice, and maybe even more importantly, how to use them effectively. So we're going to hear from the panelists, and they're going to present 4 real-world case studies and try to shed light on those questions through their discussion of the Title VI complaints that they've worked on and been involved with. And each one is going to kind of focus, I think, on a different part of the process to try to shed light on how to use these complaints effectively. So I'll go ahead and introduce the panelists. We're going to hear first from Ajmel Quereshi. He's senior counsel at the NAACP Legal Defense Fund and director of the Civil Rights Clinic at Howard University School of Law. He previously served as staff counsel at the American Civil Liberty Union's National Prison Project. He's published in several legal journals and has been quoted in the Washington Post, the Baltimore Sun, and on National Public Radio, among others. And Ajmel is going to be talking about the Red Line in Baltimore, and I think focusing on the importance of community relations and community building, community relationships in Title VI work. After that, we'll hear from Anna Sewell. Anna's at the end there. She's my colleague at Earthjustice. Anna is a water project attorney with the Washington, D.C. Office of Earthjustice. She advocates for clean water for all in the D.C. region and nationally. Anna previously worked as an associate attorney in Earthjustice's Seattle office, focusing on issues related to endangered species protection, renewable energy, and fossil fuel transit projects. Prior to working at Earthjustice, Anna taught courses at Penn State University and clerked for the Pennsylvania Court of Common Pleas. And Anna is going to be talking about a Title VI complaint that we're working on at Earthjustice that's focused on access to functional wastewater treatment in Alabama. After Anna, we'll hear from Marianne Engleman-Lado, who serves as a lecturer at both the Yale University School of Public Health and the Yale School of Forestry and Environmental Studies, where she supervises interdisciplinary teams of law, environmental, and public health students. She's also of counsel with the Poverty and Race Research Action Council, a nonprofit civil rights law and policy organization. Among other positions, Marianne previously served as a visiting clinical professor of law at Yale Law School and as a senior staff attorney at Earthjustice, maybe sensing a theme here, where she focused on civil rights enforcement. And finally, but not least, we'll hear from Vernice Miller-Travis. Oh, sorry, I should say what Marianne's going to be talking about. She's going to be talking about CAFO issues in North Carolina. And actually, before we get to the case studies, Marianne will start us out with an overview of Title VI and how it functions and what goes into a Title VI complaint. And then we'll hear from Vernice Miller-Travis, here to my left. Vernice is Senior Advisor for Environmental Justice and Equitable Development at Skeo Solutions Incorporated and serves as part of their Community Planning and Revitalization Group. Vernice is a pioneer in the field of environmental justice, a sought-after public speaker, a published author, and a nationally recognized racial and social justice thought leader. Vernice serves on the boards of North Carolina Land Loss Prevention Project, the Patuxent River Keeper, Clean Water Action and the Clean Water Fund, NRDC Action Fund, and the Smithsonian Anacostia Community Museum, and is the co-founder and a member of the board of directors of We Act for Environmental Justice. And Vernice will be talking about Title VI complaint that was filed in Maryland with regard to the concentration of power plants in Brandywine and Prince George's County.
Case he should be talking about because he wrote the original complaint.
So with that, I will pass the mic to Marianne, who will give us an overview of Title VI.
Thanks. How many of you were not in the last session? Okay, a few of you. Okay, good to know. I'll start. So thank you very much, and it really is an honor to be on this panel with everyone. I'm really excited. I'm going to start with this short overview of Title VI, and I apologize for those of you who are really familiar with the law. I want to make sure we're all on the same page. I have up here 2 photos. For those of you who were here in the last session, you'll recognize Naima Muhammad. She is she's executive director, co-executive director of North Carolina EJ Network, and later I'm going to be talking about our Title VI complaint in North Carolina, and she is one of the leaders together with Devon Hall, who's also here. And of course, on the other side, there's the signing ceremony from 1964 for Title VI of the Civil Rights Act of 1964. Anyone know why it's called Title VI? There are other titles. So that's the key thing. Were you going to answer?
No, I thought that was a question for the audience.
I thought Vernice was going to answer.
It's the 6th title?
It's the 6th title. The point is, this is a broad-based, really significant civil rights law in 1964. JFK has died. It was ready to go. He becomes sort of martyred in myth, and they're able to pass this civil rights law. And this is only one piece of a really broad remedial statute that's supposed to do something about civil rights in this context. That's important, that it was part of this larger, major hoped for transformation in American society. The other thing that's important is it's 1964. And for those of you who work in the environmental context, when was EPA started? 1970. It wasn't around in 1964. So those agencies that were part of health, education, and welfare, now HHS or education, or those agencies that existed, Transportation HUD, they had experience using Title VI. They desegregated, at least formally desegregated Southern schools with Title VI. They desegregated hospitals with Title VI. They developed a culture of using Title VI. EPA did not do that. EPA started it started as an agency during the backlash to the civil rights movement, the Nixon administration. And it really didn't entertain its first complaint until Bill Clinton came into office. So it is no wonder that it's so far behind. So I'm going to presage some of the problems we're going to talk about, but let's get back into the content. So what does Title VI say? Title VI says, no person in the United States shall, on the ground of race, color, or national origin. Now I'm going to pause. Notice it doesn't say class, it doesn't say low income. When we think about environmental justice, we think about race, color, national origin, and low income. This is only about race, color, or national origin. And national origin is like ethnicity. Okay? On the ground of race, color, or national origin, no person, you don't have to be a citizen, no person shall be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance. So it's not just the federal money that they're given. If a program or activity is given federal money, it can't discriminate at all in the whole program or activity. So University of Maryland, where we're sitting, or the School of Public Health gets money, the whole School of Public Health can't discriminate, not just the little bit of money that they've gotten, okay. And notice also, it's so broad, be subjected to discrimination, denied benefits, excluded, these very broad categories, and it doesn't say only intentional discrimination. It says you can't discriminate. And then the next part of Title VI, which I've got up there, leaves it to the agencies of the federal government to say, okay, go figure out what all this means. Go pass some regulations, okay? So each of the agencies passes regulations, and here are some samples from EPA. And each of the agencies says, not only is intentional discrimination prohibited, but actions with an unjustified disparate impact. The language here, I'll read one of them. You can read for yourself or find them at 40 Code of Federal Regulations, Part 7, if that's your thing. A recipient shall not use criteria or methods of administering its program which have the effect, not just the intent, but the effect of subjecting individuals to discrimination. Every agency prohibited actions with that were intentionally discriminatory, and also actions with a disparate effect. And we know that most of what we do, even if we're well-intended people, we discriminate. Most of what we do is not conscious. And there are a lot of maybe not so nice people in the world. But in addition, if you're in an agency, you do a lot of things that maybe you didn't want to screw people of one ethnicity or another, but you have a way of doing things, especially in a society where that was racially segregated, where racial patterns are baked into the way we do things, that each decision we make, what this law says is every decision we make, we should think about, is it having a racially disproportionate impact? And if it is, let's figure out why, and let's see if we can do something less discriminatory. It's essentially preventative. Let's try to figure out whether things are racially discriminatory. If they are, let's stop it. Let's not exacerbate these patterns of race discrimination. So every agency prohibited actions with an unjustified disproportionate impact. And what happens is, originally, until 2001, we could go to court to enforce these regulations. But in addition, federal agencies could either go out and investigate whether there was a violation or take complaints. And that's some of what we know in the area of the environment, that some of us have filed complaints, and you file the complaint with the agency that gave the federal money. So if we're filing a complaint about University of Maryland, where would we likely file a complaint? Department of Education. And if you're unsure, because it could be a private entity, let's say it's Waste Management, just for instance, maybe Waste Management, first of all, maybe they don't discriminate. I'm not trying to defame them. But let's say it's Waste Management. You can look up at usaspending.gov and see if they've gotten any grants, and if so, was it from Department of Energy or EPA or someone else? And you can see whether they receive federal money and are subject to Title VI, okay? So every agency has these regs, and you can file a complaint with the agency, and then you look to the regulations of the agency. So if I'm filing with EPA, I look at EPA regulations. What's prohibited, what's allowed, look at their guidance, what do they have to do, and also do they have guidance over it that can tell me how will they conduct their investigation. And one of the things that I have to give the Obama administration credit for is during the course of the administration, they created a case resolution manual. And it was for the first time. And it gives you some guidance as to what they'll do once you file. Okay, so what is this disparate impact analysis? This is really important in the area of the environment, in part because, as I said, discriminatory patterns are baked in, and then every permit you file could reinforce those discriminatory patterns. We might have discriminatory zoning that is a holdover from segregation, for example. And then every time you do a permit and it reinforces those segregatory patterns, it will have a racially discriminatory impact. So what is that? You have to show there's an action, policy, or practice, something that the agency did, like approving a permit, that caused harm or a denial of a benefit, and that it disproportionately harmed people of one racial group or another. or one ethnicity or another. And then, if all of that is true, that there was an action that was taken, actually in the last 180 days, that's important, that had an adverse disproportionate effect, was it justified? Okay? Did they have a reason for doing that particular thing that was a legitimate reason? And is there a less discriminatory alternative or a way they could have mitigated? This is such a powerful idea that if you send out federal money, that you're asking the agencies, you're asking recipients of federal funds to think about what they're doing and to try to make sure they're doing things in a less discriminatory way. So what are the potential violations? You can always file a case of intentional discrimination, and we can file that in court or with the agency. We can also go forward with a failure to provide language access, because if you don't provide services in people's language, it's a denial of the program because they can't access the program. So that's a Title VI violation under a lot of case law. You can challenge actions, policies, or practices with an unjustified disproportionate impact. You can challenge exclusions from participation in the process or failure to evaluate a disparate impact, because if they don't evaluate it, how could they possibly know whether they're in compliance? Now, I mentioned in 2001, it became more difficult to bring anything but an intentional discrimination case. And just quickly, that's because of this case, Alexander versus Sandoval, in which the Supreme Court said, we're not questioning whether those regulations are valid. But what we are saying, actually, there was a footnote that invited people to question, but let's put that aside. At this moment, we're putting that to another time. What we are saying is you can't bring a case under only the regulations. You can't bring a case for disparate impact in court. You can only file a complaint with the federal agency. And what that did was make us dependent, reliant on federal agencies for enforcing the law. You can still file an intentional discrimination case in court, but if you don't have the evidence of intent, either inferred or direct evidence, then you have to file with the federal agency. So if a federal agency stinks at this, as EPA does, then you're in trouble. And that's sort of the conundrum. I will say we have Ben Hewley here. He's from Senator Booker's office, and Senator Booker and other members of Congress, Congressman Ruiz and others, have a fix for this that's in Congress, the Environmental Justice Act of 2017, soon to be 2019, to try to address this and to build some momentum toward addressing it. Very quickly, agencies have to, when they get a contract, they have to say they're complying with the law. So you should know that they have this assurance that they're going to comply. And you should also know that some of the agencies have really much stronger guidance to tell the recipients of federal funds what they need to do, that they need to do an equity analysis. They need to evaluate whether they're complying. I'm going to go through this really quick because I only have like 1 minute. So if you have an administrative complaint and you want to file this complaint, am I over? Oh, good. Okay, so if you want to fight, you feel like you're working in a community or you're in the community and you say, gee, this action that this recipient of federal funds is taking has a discriminatory impact, what can I do? You can file an administrative complaint. You file it with the agency that gave the federal money, and it must be filed within 180 days of the action. At EPA, it must be in writing. And so you have to check that the recipient actually gets money, and that it's within 180 days. And you have to say this is about race discrimination. You have to say something about the merits of the claim. I will say, and we talked about this in the last session, that good practice would be to do a lot more than that. Good practice would be to really develop the claim and present to EPA or present to the Department of Transportation, this is what's going on, this is the evidence for it. And we can talk more about that later, and you'll hear some examples of that. After you file the complaint, you can always supplement the record. Okay. So the administrative process, once you file the complaint, they have 5 days to give you notice saying, we got your complaint. They have 20 days to do what's called a jurisdictional review, just saying, are you alleging something that we can investigate? Is it within the last 180 days? Does it say race discrimination, whatever? And then if they take the case for investigation, they have 180 days to make a finding. Now, I will tell you, they don't follow the 180 days. They don't. And there's a long story, which we could talk about later, about what goes on. We don't always want them to follow the 180 days. Because sometimes, if they're going to dig deeply and we're going to provide them with evidence, it might take 181 days, and that's okay. But we also don't want them to take 10 years. And they just resolved a case. They actually made a finding of discrimination in 2017. They just resolved a case that had been filed in 1992. You don't want them to do that. So you want to dog them. You want to talk to them. You want to figure out what they're doing. And then you want to, just very quickly, once you file a case, they will investigate. They're supposed to be like the district attorney, going in and investigate. They're not. You can give them information, but they don't do a thorough investigation. So you want to dog them. You want to find out what they're doing. And there are different alternatives at that point. They might offer that you go into alternative dispute resolution. I'm going to talk about that later. You're going to hear different kind of pathways. The remedy, in theory, is that they can make a finding of discrimination and withdraw federal funds. It never happens at EPA. It almost never happens at other agencies. Instead, what they do is they'll call up University of Maryland and say, we think you got a problem. You've got this suspension policy and it's discriminatory or whatever it is. And then they'll say, let's work it out. And then they come up with a resolution and they close the case. That's generally what happens. So I've talked, I want to say one thing about this. Dangers of the Trump administration. Just to be really clear, Title VI, the law passed by Congress, right? Unless Congress amends it, it stays the law. The regulations, which I just talked about, which prohibit actions with a disproportionate impact, they're regulations. So who can change them? The executive branch. And who's in charge of the executive branch? Yes. So we are worried and watching because there were rumors that they were going to try, and they're doing this in the housing area, which is a complicated story, but they're undermining the disparate impact standard. So we're very worried that they're going to issue rulemaking to get rid of the disparate impact standard. So I just wanted to mention that, and again, we can talk about it later, because if they do, we'll need all of you to get involved. We can stop it. We can stop rulemaking, especially if the clock is ticking on this administration, but that's a very scary notion. The promise of this law has not been fulfilled, but we want to fulfill it, right? There is no reason Title VI shouldn't be enforced in this context. And if we're going to do that, we've at least got to hold on to what we have, and your voice makes a difference. So very quickly, you're going to hear stories about why we file. I've already mentioned that in the EPA context, EPA's record has been weak at best, but nonetheless, communities across the country have used this to try to raise issues of discrimination, try to get leverage, try to get into a room to negotiate. I just, in fact, was sitting down with the head of environmental justice in Connecticut, and she told me that in 1995, someone brought a Title VI complaint. I had never heard this story, and that the governor was going to get rid of her office, the Office of Environmental Justice, and because the Title VI complaint was filed, her office was saved. You just never know what kind of leverage you get. So looking to 2020 and beyond, we must enforce civil rights. Thanks.
How are y'all doing? Good. Just okay. I feel you. How many of you have seen An Inconvenient Truth, the movie, right? So I think of my Title VI talks, and I should say, I'm grateful to Marianne for inviting me, because Marianne, I really think she is one of the leading experts in the country on Title VI, and she is. Not only does she bring the knowledge, she brings the heart. She is an evangelist for Title VI, and I think it's fantastic. And I also think it's fantastic that despite the fact that I am, a cynic would be too strong a word, I think I've just been burned. So I'm going back to The Inconvenient Truth. Of course I love An Inconvenient Truth because it's about environmentalism and all of that, but the part of the movie that actually sort of struck me a little bit is the middle of it, where Al Gore, talks about, losing the election and then getting back on the road and pulling out the old projector and going around the country and giving the talk. And that's kind of how I feel about my Title VI talks. I'm going to spoil the ending for you a little bit of my Title VI adventure and tell you that in the end, it ended with formally, and we can say whether or not that's the actual end or not, and we don't know yet. I mean, I think it depends on sort of if Governor Hogan runs for president or who replaces Governor Hogan when the next gubernatorial election happens. But at least for now, the end of this story for now has a less than happy ending. And I think a lot of what I'm going to talk about over the course of the next 10 minutes is going to be, I'll give you some facts about the Baltimore Red Line, but I also will just share with you a lot of lessons from my experience filing the complaint, dealing a tiny bit with DOT, although my focus is going to be heavily on sort of the community focus and community organizing and establishing relationships of trust. And then sort of what you do if your complaint meets an untimely end. So let me tell you a little bit about the Red Line case as well as about LDF. How many of you know who the NAACP Legal Defense and Educational Fund is? Got it. All right, so some of you. We're one of the nation's largest longstanding civil rights organizations. And I think it's relevant to think about LDF as a large bureaucratic institution that does good things, but it is a large bureaucratic institution. I'm telling some truths today. Hopefully you won't run off and report me to my boss, although I think she's heard me say this as well before. And I'm a creature of large bureaucratic institutions. You know, it's been 4 going on 5 years at LDF, and before that was 5 years at the ACLU's national office, which as well is a large bureaucratic institution which does good things, which is very hierarchical. And that's relevant, I think, to what I'm going to talk about today. So let me tell you a little bit about the Red Line. So the Red Line, how many of you are familiar with what the Baltimore Red Line would have been? Okay, so many of you. So it's...
We're from Maryland.
That's right. That's right. But I mean, it's funny, and I'll talk about a little bit about the death of the Red Line in terms of how it really was sort of Baltimore against the rest of the state in the way the governor pitched it, or at least pitched the Red Line's replacement. So the Red Line would have been roughly a 14-mile light rail line that would have run east-west throughout the Baltimore region. It had been in unofficial planning all the way back to 1965. Many people don't know that Baltimore was supposed to have a metro system not too different from the one in Washington, D.C., with 5 radial lines existing and running out from the center of Baltimore. In the end, Baltimore got 1 light rail line and sort of half or a quarter of a subway line that doesn't really sort of go anywhere or do much of anything. This, in terms of official planning for the Red Line, it had been officially planned since 2001. And what official planning means is federal, state, and local partnership to study the Red Line, where it should go, how it should be structured, what materials should be used, environmental impact, so on and so forth. When Governor Larry Hogan came into office in 2015, he came into office in January of 2015. In June of 2015, just 2 months after the death of Freddie Gray, he canceled the Red Line. The Red Line would have run through Sandtown, Winchester, the neighborhood where Freddie Gray lived and died, where almost 50% of people don't have a car, where unemployment runs up and around 26%. The Red Line would have provided access to individuals to jobs, hopefully medical resources, potentially construction jobs in their neighborhood that hopefully would have increased the quality of life in neighborhoods like Sandtown, Winchester. It was a $3 billion project, including $1.35 billion in new capital funding. Included $900 million that was going to be given from the federal government. And by the time the Red Line was canceled in June of 2015, $290 million had already been spent on the Red Line. So it's been unofficial planning since 1965. Official planning since 2001, close to $300 million had actually been spent by the time the governor canceled it, shortly 5 months after he came into office. So that's how quickly things changed. LDF filed a very extensive, in my opinion, Title VI complaint. We hired an expert who used something called the Maryland Transportation Model. This is a model from the State Department of Transportation, which allows you to map the cost of moving from any one point to the other. So we hired an expert who mapped out the next 20 years of costs for every single individual in the state in terms of getting to work, dropping their kids off, so on and so forth. It was a very extensive, expensive study. It's going to make sense in a second why I'm telling you all this. We also filed a complaint that was roughly 45 pages long and included 26 exhibits as well. I would dare say that there have been few Title VI complaints that were extensive and as expensive as the one that we filed. And ultimately, what happened is the Trump administration, once they came into office, essentially closed the complaint in July of 2017, so 6 months after they came into office. And they gave a one-line explanation that the scope of the complaint was too big and they were closing it. So this was 2 years after we filed the initial complaint, after they had gone into the community and done extensive interviews, after they'd made 3 document requests to the state of Maryland. They closed it because the scope was too big. This seems like the type of thing that if they were going to do, they should have done it the moment that they received the complaint in December of 2015. And so I've always viewed it as cover. But I want to be honest with you. I'm not confident that the line attorneys in the Department of Transportation would have come to a different conclusion. And I'm very harsh on them. And I think it's a product of my experience with them. My experience with them is that the political appointees had the will and had the courage and had the commitment to making something happen in this case. So in January of 2017, the day before the Obama administration left office, a political appointee wrote a fairly extensive letter making initial findings in the case, concluding that the governor's office had failed to consider the disparate impact before it made the decision, and that it was expanding the scope of our complaint to cover all of the state's transportation activities. And this, again, happened in January of 2017. 5 months later, the Trump administration closes the complaint because of scope. But that, again, was the political appointees. That was a decision written by the political appointees in the Department of Transportation. The actual investigator that I worked with on a day-to-day basis was skeptical about the complaint from day one. And he was a career person. And I don't, to this day, and I don't have any answers for you. I'm not sure how I could have won him over. But I think that ultimately is one of the challenges, and I think somebody else is going to be talking about this, is that once you file the complaint, you have to think about it the way you'd think about it working with a judge. You have to win over that individual who's working on the complaint. And I think that, you know, the way LDF does a lot of our work, we did an extensive media push when we filed the complaint. We had spent all of this money on experts. And I think my initial read of this individual was 2 things. One, that he was put back a little bit by that he was like, look, I'm the expert. Who are you sort of bringing in all of this information and sort of overwhelming me? This is my job. I should be doing this. I mean, so that leaves the dilemma. Does that mean that I file a weaker complaint? So I think that's something that I've always struggled with. And then I think the second aspect of things that I've taken away from my dealings with this individual is that ultimately, at the end of the day, you have to think about all of these things in the context of the individual that you're working with and whether or not they have the political will to do what you're asking them to do. It's a different situation if you're in Ohio, and this is a real Title VI complaint, and the complaint is just about one particular stop and whether a stop was built or not in a primarily African-American neighborhood. It's another thing to say that $1.35 billion needs to be redirected from the governor's state highway, bridges, and roads project, which is what the governor did once he canceled the red line. He moved all of the money to highway projects in other parts of the state. It's a much bigger ask. And ultimately, at the end of the day, if the individual that you're dealing with, who's a career line attorney, who's going to be there long after the complaint is filed, doesn't have the political will or the political courage to do what needs to be done, you're in a tough spot. And that is my read of this individual, that, you know, ultimately he did not have the courage to sort of push this complaint, and he wanted to get rid of it as quickly as possible. And that was the message he repeatedly communicated to me, was this is so big. It's so much bigger than all the other complaints you reference. It's so big. It's so different from everything else that you're citing because of the scope of the money involved. So those are some of my lessons from the Red Line case. With regards to community experience and working with the community, I really have three things that I want to talk about really quickly. One, you have to do a good job of sort of educating the community members you're working with about what Title VI is. Now, that not only what Marianne laid out with regards to sort of the legalese of Title VI, but explain to them, this is not a court that you're filing with. You're not going to be able to necessarily come in and testify. They're not going to necessarily follow regular deadlines. They are not even necessarily going to work through your counsel. So, this individual who was investigating the complaint, he was very worried that sort of LDF was speaking for the community. And so he repeatedly would try to go into the community and do individual investigation, even talk to our individual plaintiffs without contacting LDF and then only telling LDF later. And so I think that none of the rules that normally apply in a court necessarily apply in a Title VI context. And so you have to educate the community that this is more of an informal process in court. There may be no chance where you get to go into a formal room before a podium and give testimony or something like that. There's not necessarily, as Marianne laid out, they're not necessarily going to strip funding from the agency. And so you have to educate them about the differences between a Title VI complaint and the formal courtroom process. Number two, you also have to set expectations. And this is I think it's a big part of all of my work that I do with clients in the Title VI context or not. And it's very difficult because me setting expectations, especially when I do it poorly, which I sometimes do, can be interpreted as me telling the community what they want. And I think you have to balance the difference between sort of communicating to the community, this is what I think you want, from telling them realistically, based on my experience, this is what we realistically may get out of this process. And that specifically played out in the context of the Red Line, and that a lot of the community groups that I worked with were dead set in the belief that this process, filing a Title VI complaint, would end with the Red Line being built. And that was problematic because most significantly, the $900 million from the federal government was gone. I mean, it was gone right away. It was gone within 6 weeks. It had been reallocated by the Department of Transportation to other projects. And so you would need Congress or the agency to reallocate new money. And even if we won the Title VI complaint, it may take time for that to happen. And so I tried really hard to communicate that to individuals that, look, the outward face can be build the Red Line, build the Red Line, build the Red Line. And there's reasons for that, because ultimately the decision to build the Red Line is a political decision. But internally, we may have to be honest that the end result of this process may not be building the Red Line. So at least we should consider what other suitable alternatives work for us. That was a very difficult conversation, and I'm not sure it always necessarily went well. And then finally, the last point I want to make, the third point, thank you for being very patient and listening to me prattle on with my sort of war stories, is that organizations like LDF and the ACLU and other large organizations that do civil rights work that are structured in the way that we're structured often talk a lot about community work, which is great. And I genuinely think that LDF and the ACLU and other organizations are genuinely committed to community work. But there is an inherent conflict between the way decision-making works organizationally and the way decision-making works in the community. LDF, like many organizations, like most law firms, is a hierarchical organization where, yes, I have a great deal of leeway as an individual attorney, but ultimately, we all have masters to serve. We have people to answer to, decision makers. And so it is a hierarchical decision-making process. That oftentimes is not the way that community decision-making works. And when those two things meet, there can be conflict. And oftentimes community members will see me and they will think I am the voice of LDF all by myself, and I am the ultimate decision maker for LDF. And it was the same way when I was at the ACLU. Community members would see me, and I do a lot of prison work, so I'd be going into prisons a lot. So individuals who are incarcerated would see me and they would think, he is the voice of the ACLU, this tens of millions of dollars organization with 200 national staff attorneys around the country, in addition to the 51 affiliates in different parts of the state. But we all have masters to serve. And so ultimately, we would like to serve the community the best way possible, but oftentimes it takes time for me, the individual attorney, to get the rest of the organization on board to where the community is. And that, I think, just in terms of timing and the structure of decision making, oftentimes would be a point of conflict. The final thing I want to say, and then I will stop, is ultimately, and this is, I think, where Marianne and I have had some productive conversations over the years is, how do you assess this experience with Title VI? This complaint that we spent $50,000 on, that we filed all of these exhibits, that we did all of this media work that ultimately ended in the complaint closing. What do you, both for the community and for myself as an attorney, how do you look back on the process? Do you ultimately call it a win or a loss? And so I think that when I'm in a room of attorneys and when I'm honest and I'm speaking for myself, I call it a loss, because ultimately at the end of the day, I'm at the point in my career and the way I think about the world in that ultimately it's about how many lives you save. And I look at sort of all of that money being gone and being invested in other places. And I have hard conversations with myself about, ultimately if I have two cases to file, and in one of them I can go into court and one of them I can't, it's a significant advantage to be able to go into court. Does that mean that we should abandon Title VI? No. But I think it's the hard conversation that I often have in my head. And I think this is why I love to be on panels with Marianne, because she is the evangelist and she's right. But I think that I think I am the cynic in that ultimately I don't know that if I had to do it all over again, whether or not I still would have filed the Title VI complaint, because it was $50,000 down the drain. It was a lot of time. It was a lot of money. And I don't know how this story ends. If the story ends, and this is the positive aspect of it, so this is the other side, we kept the red line alive in the political sphere. It was a big part of the gubernatorial election. Ben Jealous, when he ran, talked about the red line. There are community groups that have been spawned because we filed the red line complaint. They still meet. They still meet in Baltimore. They still organize around other transportation issues. People still write about the red line. I just filed a case in Maryland having to do with the gross underfunding of Baltimore City public schools. And in the op-ed that the Baltimore Sun wrote, they talked about this being another example of how the governor has abandoned the city of Baltimore along with the red line. And so it's still in the public discussion. And I'd like to say that all of those are victories. The community groups that have been spawned, the fact that it's still in the political conversation, that people who worked on the red line case are getting together and organizing around other transportation issues, that it's being quoted in Baltimore Sun editorials, up until this week. I'd like to say that those are all victories, but I also, again, at this point in my career as a lawyer, am very tired of sort of patting myself on the back and sort of living in false victories. And so really, at the end of the day, before I give this talk, when I sort of sit down on my couch the night before and gather all my thoughts, and I have my glass of whiskey, and I look deeply into it, I ask myself, is this a win or a loss? And I don't know the answer to that question. Thank you. Too much whiskey.
Before Anna gets started, I just want to say we did get started a little bit late. I don't know if they're going to be kind to us and generous to us and give us official permission to go a little bit past 5. It's okay. I'll make the executive decision to try to go a little bit past 5 so that we can have some time for discussion, maybe until 5:10 or so. So it's right now it's 4:30. Yeah. So if maybe
4:59. That'll mean we'll be at 4:59 when Marianne finishes before typically stick to 10 minutes.
Let's figure it out while Anna's talking.
Yes.
I'll go quickly. Good afternoon. I'm going to share with you how we developed legal and factual support for a Title VI complaint that we filed on behalf of the Alabama Center for Rural Enterprise last year regarding disproportionate lack of access to basic sanitation in Lowndes County, Alabama. And I'll say Neil is on this case with me as well. He's my co-counsel, so he can also answer questions about this. Start with some background about Lowndes County. It's in south central Alabama in the Black Belt region of the state, which is known for its dark, fertile soil. It's also a very rural area where more than 80% of the population does not have access to a municipal sewer system, which means that people must use some sort of on-site wastewater system. So typically that's a septic tank. It's 74% African American, and I want to also point out on the map, if you look at the pink band, that's blackland prairie soil. And it cuts right through that Black Belt region, including Lowndes County. Blackland prairie soil turns out is a very shrink swell kind of soil is what they call it. And so it's very impermeable. And the way a septic tank works is the wastewater is supposed to permeate through a drain field. That doesn't work in this kind of soil. And so for a lot of folks who buy a conventional septic tank, it simply fails. The alternative is an engineered septic tank, but those can cost anywhere from $6,000 to $30,000. Very, very expensive, out of reach for most families in Lowndes County. About 29% of the population in Lowndes County lives below the poverty line. These economic disparities are highly racialized. Only 4% of white residents live below the poverty line, while 37% of African American residents live below the poverty line. So when you don't have access to a municipal sewer system and your septic tank doesn't work, sometimes you are forced to resort to other alternatives to get the wastewater out of your home. And so for a lot of folks, that unfortunately means they are forced to use straight pipes, which is what it sounds like. It's a pipe that connects with your indoor plumbing and goes straight out to your backyard, to woods, to the creek nearby. Sometimes they're visible, sometimes they're buried, so you can't see them as well. The Alabama Department of Public Health once estimated that somewhere between 40 and 90% of residences in Lowndes County either have a failing septic tank or no septic tank at all. But when the UN visited in 2017 and interviewed them about this, they said, well, we don't really know the number and we don't have any plans to find out. And in neighboring Wilcox County, which is pretty much right next door, sorry, I don't have my map up anymore, but there was a good survey done recently there of 289 homes, and they found that 93% of residences in Wilcox County out of those 289 homes had some sort of an unpermitted septic system. So that was 60% had a visible straight pipe, 34% had either a hidden straight pipe or some other form of unpermitted system. So we know that this is quite common, and it leads to a lot of raw sewage on the ground, which causes a lot of public health risks, as you might imagine. Very alarmingly, one of those risks is hookworm. This is a disease that we believed was eradicated in the US, but unfortunately, we now know that it's not. In 1993, in a study in Wilcox County, they found a lot of children had hookworm. Much more recently, there was a peer-reviewed study from some researchers from Baylor University, and they found that 34.5% of study participants tested positive for hookworm. Not only did the Alabama Department of Public Health not do anything about this, they didn't investigate, they didn't offer medical treatment, they didn't educate the public, but they also, in April of 2018, put a notice on their website that said that this study did not find evidence of hookworm, which is simply not true. We explained that in great detail in the Title VI complaint that we filed, but it's inaccurately telling residents that they have nothing to worry about when in fact there is evidence of hookworm. So we've been working with the Alabama Center for Rural Enterprise for a couple of years now. It's a small nonprofit founded and directed by the wonderful Catherine Flowers. She's been working in Lowndes County, Alabama on this issue for well over a decade at this point. And when we saw that the lack of access to on-site wastewater treatment was disproportionately less available to African American residents in Lowndes County, we began investigating a Title VI complaint. And so we started with the legal investigation and the basic question of, well, who has authority over sewage issues in Alabama? The Alabama Department of Environmental Management has authority over municipal sewer systems, but the Alabama Department of Public Health is the agency with authority over on-site wastewater sewage systems. And since more than 80% of the population must use an on-site wastewater system in Lowndes County, and the Department of Public Health also has authority over sanitary conditions and over protecting the public health, we decided to focus there. And so if you look at Alabama's laws, the Alabama Department of Public Health has some really fundamental duties to correct what they call insanitary conditions. And so they have to fix these situations when they see them. They also have a duty to issue permits to homeowners for new septic tanks and repairs of septic tanks. However, the burden to maintain a sanitary septic system actually falls on the homeowner in Alabama. And in fact, it's a misdemeanor if you don't maintain a sanitary system. And in the early 2000s, they issued arrest warrants for at least 10 African American residents. The Alabama Department of Public Health also has broad authority and duties to investigate diseases and outbreaks, which they define as 2 or more ill individuals in different households with common exposure. So the other category of legal research that we did was related to the jurisdictional requirements that Marianne also touched on in her presentation earlier. And so the program or activity requirement, that includes both state agencies as well as local departments, as long as they also receive federal funding. We looked at the situation in Alabama and saw that the Lowndes County Health Department actually acts as an arm of the Alabama Department of Public Health, and that they share in the duties under state law. And so we included both in our complaint. For the federal financial assistance requirement, Marianne also mentioned the usaspending.gov website is pretty intuitive and easy to use to just look up which agency is funding which federal agency is funding which state agency and the amounts. And here's just like a snapshot of part of the spreadsheet. We actually went all the way down to 2008 in our complaint and totaled it all up, but that's just a portion of it there. Timeliness, you do want to file your complaint within 180 days of the last alleged discriminatory event. And then finally, other jurisdictional requirements are things like it has to be in writing and describe what the discriminatory act is that you're alleging. Factual investigation. We relied on a very wide variety of factual resources for this complaint. We started by visiting Lowndes County. We joined the UN Special Rapporteur on Extreme Poverty when he visited in December of 2017. He was doing a tour of the U.S. Looking at human rights abuses throughout the country at that time. And we joined him in Lowndes County, and we got to meet with several families and see the conditions for ourselves and talk with folks. And that also led us to other resources. So for example, the book I have a picture of here, Bloody Lowndes, is a book that one of the residents told me about because her family is featured in it. And this is a book that's about the history of Lowndes County in the civil rights movement. And so even though it doesn't mention sewage, it actually was really helpful factual and historical context for the complaint. And it allowed us to really connect the dots between the history and what we're seeing on the ground now. We also relied on a couple of UN reports because the UN has actually visited Lowndes County twice about this issue. News articles, academic articles. We looked at soil maps, several soil maps, things like that. We found out that there were town halls held in 2002 when the arrest warrants were happening. And our client wonderfully hired a court reporter to take transcripts of those town halls, but then we couldn't find them, and nobody knew where they were. We finally tracked them down. They were at a nonprofit here in DC, actually. They were like, well, they might be in the basement somewhere, we don't really know. So they couldn't find them. 2 months passed. Then they called me up out of the blue one day and said, "Oh, we found them." So that was exciting. So you never know. We hunted far and wide for our historic resources. We also heavily relied on the Census Bureau's American Fact Finder feature on their website. This is really, really useful for Title VI complaints because it not only compiles census data, but also American Community Survey data. And so that's things like housing information and poverty information. So we were able to, for example, get racial data about who owns mobile homes in Lowndes County, and also get the median value of those homes. So things like that are available on American Fact Finder. And then finally, we had done all this factual investigation. We'd collected a lot of data, but we still didn't have good facts about the central core problem here, which is residences that lack access to a functional septic tank or to any septic tank whatsoever. And that's because the census stopped asking about this issue in 1990, and the state doesn't collect any information on it. We asked them, they said they don't collect it. The only data that they do collect is permits for new septic tanks and repairs of septic tanks. And this lack of data collection means that they also aren't collecting data on who, demographically, who is benefiting from their on-site wastewater program. So that actually formed part of the basis of one of our claims in the Title VI complaint. We also did what we could with the data that we did have. And we combined that Alabama county by county permit data for new septic tanks and repairs of septic tanks with census data on the racial makeup of each county. And we put that all in Excel, and then I'd never done this before, but we figured out how to just very easily make it a graph in Excel. Apparently you can do this. And it was pretty easy. And it showed, as you can see, a very clear trend that as the proportion of white residents in a county in the Black Belt increased, so did the proportion of permits for septic tanks. Conversely, and this might be slightly blocked, but there's a downward trend as the proportion of Black residents increases in the county, the number of permits clearly decreased. And we did control for population size. So this is with the controls for population size in the county taken into account. And we use this to demonstrate that the African-American residents in the Black Belt counties, like Lowndes County, are less likely to have access to septic tanks. Our complaint's still pending, so the conclusion is to be determined. But I hope that was some helpful background on legal and factual investigation.
So I'm going to turn back to the case we were talking about in the last panel on the challenge of the challenge to North Carolina's permitting of hog operations. For those of you who weren't here, we brought a Title VI complaint to challenge North Carolina Department of Environmental Quality's permitting of more than 2,100 hog operations that have tremendous impacts on people in eastern North Carolina, which disproportionately affect African Americans, Latinos, and Native Americans. We brought it on behalf of North Carolina's EJ Network, a group called REACH in Duplin County, which is the most affected county in the world by hog operations, and Waterkeeper Alliance. And it's been a long struggle. We talked a little bit in the last panel. What are we seeing here? Oh, well. We talked a little bit about what gave rise to this effort. I'm not sure why you're seeing all that stuff. It doesn't matter. So my focus is going to be to sort of skip pretty quickly to the use of alternative dispute resolution. And I will say, just to follow up on the earlier comments, and I don't drink whiskey, but maybe I should. We did in that context, and we talked about it a little bit last time, we did really advise the clients that they're not likely to get anything out of the case. And I think keeping expectations real is really important in these cases. But there's no doubt, and people have been fighting in eastern North Carolina for decades about the environmental justice impacts. And this is just a picture of the spraying of hog waste into the air in a typical swine facility. And you see when people go outside, they go to their garage, they try to sit on their screen porch. They have hog waste coming into their face. I myself have felt it on my face and my hands, etc. And so I'm not going to spend a lot of time on the merits of the case, but trust me, A, hog waste is gross, and B, that it racially disproportionately affects people of color in Eastern North Carolina. So we filed this complaint in 2014. It was filed with the EPA. Trust me, if we could have filed with another agency, we would have. We couldn't, we didn't, and we were stuck with EPA. There are pros and cons of going into alternative dispute resolution. Alternative dispute resolution is a formal program at EPA. They actually have a bank of certified mediators. Actually, Vernice is a mediator in the program. So if you're lucky enough, maybe you'll get Vernice. If you file a complaint, like we've all talked about, as I said, it's like going to the district attorney. It's EPA that does the investigation. They don't even consider you a party. They have to notify you, but it's their shtick. It's their thing. They investigate. They have obligations to talk to the recipient of federal funds to try to get voluntary compliance. And unless you're super lucky, it's all sort of happening over here. Now, we've been advocating for years to include complainants in that process, but it's all sort of over here. One of the benefits about going into the alternative dispute resolution is you are a party in alternative dispute resolution. It's you and the recipient of federal funds. And then you can sort of set the ground rules. It's the mediator that you get to choose, but is on the list at EPA. So you got this mediator, which you've selected jointly with the other side. It's all voluntary. Everyone can balk at any time, but you're in that room because you're willing to negotiate, and you're negotiating directly with the other side. So there are some benefits. One, in a hostile administration, you have less leverage because everybody knows they're not going to make a finding of discrimination if this alternative dispute resolution falls apart. But it puts the investigation on hold. They're not going to close the case, and you're sitting across the table from the other side. And you're doing it with a trained mediator. And to the extent a lot of this is about lack of communication and lack of trust, you get to talk. Sometimes talking is really important. Airing grievances, developing trust, finding a way to talk to one another. And sometimes it can get somewhere. So we had a terrible experience and a good experience. So very quickly, 2015 to 2016, we went into alternative dispute resolution. McCrory administration, for those of you who don't know North Carolina, he's the guy who brought us the bathroom scandal. Right wing, not very helpful. But we were in alternative dispute resolution. They were sharing information with the pork industry. The pork industry, actually, there is no such thing as intervention. Let me just tell you. If anyone tries to intervene in your administrative complaints, it's not a thing. And we've briefed it. The long and the short, it's not a thing. But the pork industry tried to intervene in our case, and then they imposed themselves in our alternative dispute resolution. And we already said, no, this is voluntary, we will balk. We're not sitting down with the pork industry. We're sitting down with the regulators. The regulators say, but the pork industry knows everything. We're like, well, that's the problem here. And so for all kinds of reasons that are obvious, that alternative dispute resolution did not work out. Broke down. EPA comes, they investigate further, they do a site visit. And actually, in January of 2017, before leaving office, they didn't make a finding of discrimination, but they did send a letter of concern saying, we came, we saw, this was terrible, we have real concerns, we have concerns about intimidation, we have concerns about discrimination. Obama administration leaves, McCrory administration leaves, Governor Cooper, who's more reasonable, comes in, and we agree to go into a second round of alternative dispute resolution. We're in it for a year with a really excellent mediator. I'm sure Vernice would have been better, but nonetheless, a really excellent mediator. And in May of 2018, we settled, and now we are in an enforcement and implementation period. It allowed the community to develop more of a relationship with the agency. It allowed us to come to some agreement. A few quick points, and I know I'm out of time. EPA's program is at EPA's expense. It's called EPA's Conflict Prevention and Resolution Center. You can find it online. It's all voluntary. If you don't like what's happening, you can leave. It puts the investigation on hold. It's confidential, although practice tip, talk about confidentiality so you know whether it's confidential or not or what is. It's mediation, not arbitration. That is, it's not binding. There's not a decision maker. You are in negotiations, and EPA has to approve the final agreement. Complainants and recipients agree to participate. You have a dialogue. It's probably going to take a few months. You have to draft the agreement. It takes a lot of work. And let me just say, I already mentioned some challenges, but let me just spend 1 minute on that, and then I'll cede the floor. So I already mentioned that there can be distrust. And of course, in mediation, distrust can be a real problem. There's also an uneven playing field, right? You have an agency in some of these permitting cases that comes in, they have all the data, they have the experts, and you're in a community organization. Unless you can get someone to fund or get EPA to bring in an expert, you have to either fund an expert or figure out how to even the playing field, and that can be a concern. Intimidation can be a concern. There's the question of what's your leverage? If they know that the agency isn't going to make a finding of discrimination, is your leverage that you're going to leave and get them bad press? You have to really think through your strategy, and it takes time and effort. Finally, here's the positive side. We got to have some positive. In this case, the settlement, while it wasn't, we want to get rid of the lagoon and spray field system. Community is owed that. This is not that. We did not get rid of the lagoon and spray field system. But we did get them to agree to move on certain permit terms. For the first time ever, they're going to have groundwater monitoring. They did agree to create a Title VI program with a language access policy, a public participation policy, the creation of an environmental justice tool. We did get air monitoring, water monitoring. So there's a lot that came out of it. It wasn't nothing. And there are a lot of lessons learned. There are lessons learned about mediation selection, about trying to make sure the important decision makers are at the table, and how you use the mediator to create a balance of both open and directed communication. Happy to talk about any of those lessons learned. ADR is an interesting option that I just wanted to share with you. Thank you.
Okay, last speaker from last panel of day. Say something of interest, right? Oi. All right. So let me start by saying that I'm talking about the complaint of the Brandywine Title VI complaint in terms of what it imports for our state and where we go with this conversation. But I want to say that the main plaintiff and organizer behind this, Ms. Kamita Gray, and the BTB Coalition is right here in the room. Raise your hand, Kamita. Now, we have had several conversations about this complaint today, and so my job is to tie it all up into a bow to let you know how important this is to our state. While the theme of this talk is we lost but we won, right? And so it happens all the time, unfortunately, in Title VI complaints. So I have a lot of things I want to cover. I'm a New Yorker, though I've lived here for 22 years, but I'm going to talk at the speed of light. If I'm going too fast, let me know. First thing, pursuing Title VI complaints within an environmental context is inherently challenging, particularly if US EPA is involved. And if you're doing it in an environmental context, US EPA is involved. And why is that? One, because they have no freaking idea what it means to enforce the Civil Rights Act as an environmental agency. In our previous panel, Marianne mentioned, or maybe it was this panel. It was at the beginning of this panel. Civil Rights Act passed in 1964. EPA started in 1970. Not just EPA. None of the environment, natural resource, and energy agencies at the federal government level understand that they have dual obligations to enforce the Civil Rights Act and non-discrimination, as well as environment and energy and natural resource federal laws and guidance. As a result, because the federal agencies don't understand their obligations, they have never mandated that state agencies, be they environment, energy, or natural resources, be compliant with Title VI of the Civil Rights Act or any other non-discriminatory tools because they were never mandated. So whereas in a health context, previously the Health Education and Welfare, now HHS, or the Department of Education, or the Department of Transportation, have all gone down this road around discrimination many, 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 many times. And because of that, they have a mechanism and an architecture in place, and they require that state entities that receive their fundings have parallel systems. That is not the case in the environmental arena, and that's why we have this gaping hole. Most state environmental agencies have inadequate civil rights programs because there's been no mandate from EPA. One of the craziest things to ever come out of the Environmental Protection Agency is a concept called rebuttable presumption. And what is that? That is some made up cockamamie stuff that is not based in law, statute, or science. I'm still trying to find, after 25 years, who is the fool in the Office of General Counsel that first articulated this idea? And this is the principle, right? If you are compliant with environmental statutes, Clean Air Act, Clean Water Act, Safe Drinking Water Act, Resource Conservation Recovery Act, Superfund, whatever it is, you therefore have met your obligations under the Civil Rights Act. Who told you that? Where did you get that? And whoever gave you that JD, give it back, because you just did not pass the basic qualifications of a legal education, right? The landscape in Maryland and the landscape in Prince George's County. So for 13 years, I served as the vice chair, along with Andy Fellows, of the Maryland State Commission on Environmental Justice and Sustainable Communities. From 2004 to 2017. From 2009 to 2017, Steve, myself, Marianne, and a whole bunch of people from around the country were in a to-the-death battle with US EPA at the highest levels, meeting with the administrators, both Lisa Jackson and Gina McCarthy, on a quarterly basis over all those years to put our foots in their behinds about stand up your external civil rights program. Fortunately, some of us knew Lisa Jackson and knew Gina McCarthy. So we put personal pressure on them as the stand-up people that we knew them to be, to make sure that they did not leave this administration without articulating a stand-up external civil rights program at EPA. How intense was this? The Wednesday before DJT was sworn in as president, Marianne and I were on the telephone with the administrator, with the general counsel, with the chief of staff. Do not walk out that building without telling people what they should do and what they are required to do. So for about a week and a half, we had a really golden moment, right? And then it was over. But we'll get back to that. What's the landscape in Maryland? Absolutely, positively zero, rejectionist. We don't care about civil rights. This is not our job. We don't need to do this. So Andy, thank you very much. Andy and I argued with the Maryland Department of the Environment on a monthly basis for at least 12 years. You have individual obligations separate and apart from all of the environmental regs to make sure that communities in Maryland are treated equally before the law, and that racial discrimination does not inform decision-making, particularly around land use and siting. We go around and around and around and around the mulberry bush. I swear to you, there was no there. And it would get me so frustrated. So I'm the vice chair, and I'm trying to be neutral, but you can't be neutral when the people you're talking to are absolutely, completely brain dead when it comes to a conversation about civil rights enforcement, right? The best they could do was say, well, we do have a fair practices officer. A fair practices officer, right, is dealing with Title VII and Title VIII, employment discrimination inside the agency, not external civil rights. They had no idea what we were talking about. They brought in somebody from the U.S. Department of Transportation who tried to explain to them what their obligations were, clueless over their heads. So when the Brandywine situation emerges, a community that was already overburdened by anybody's standards with environmental threats and burdens that were diluting the quality of life and maybe the life expectancy of the people who live in this community, there was no infrastructure in the state to be able to respond to what they had put on the table in their complaint, right? So how many of you know they filed their complaint against the Public Service Commission and with the Maryland Department of Transportation? How many of you know why that is? So these are the two things that they're trying to get done. One, whether the process and decision to issue a certificate of public convenience and necessity to Mattawan Energy LLC for the construction of a natural gas-fired power plant in Brandywine, Maryland, discriminated on the basis of race, color, or national origin in violation of Title VI. And two, whether the public engagement process prior to the decision to issue the certificate of public convenience and necessity discriminated on the basis of race, color, or national origin in violation of Title VI. These are the two main elements in their complaint. Why is it filed with the Maryland Department of, the Maryland Public Service Commission, the Maryland Department of Transportation? Anybody? Hello, anybody? Regulator of energy, most especially regulator of pipelines. So you might think the Federal Energy Regulatory Commission or the EPA are the entities that you talk to when there's an issue of a pipeline. No, it is the U.S. Department of Transportation and the Pipeline Hazardous Materials Safety Administration, which is an entity within the U.S. Department of Transportation. So all issues related to pipelines are running through DOT, not EPA and not FERC. So they're challenging these two issues. They're telling them that they have cited multiple power plants already in this community. They're also the host of almost all of the coal ash landfills in the state of Maryland are in this community. They have impact after impact after impact. And so the question is, when does it get to be enough? When have we absorbed so much impact that we need the state to step in and say that we are being discriminated against on level upon level upon level upon level? When does that happen? They file a Title VI complaint. Long story short, lots of elements in the alternative dispute resolution that they force them into. Okay, we'll be there. Many elements in this, of this settlement. In fact, there are A through H entities, subparts of it. But this is what they focus on in response to their complaint to stop a power plant, to deal with cumulative impact, to make sure that they don't have any more air pollution burden. This is what they responded in this resolution. Community outreach and public participation. That's good, right? We all want more community outreach and public participation. A notification and improvement process. When the Public Service Commission gets an application for a new power plant, we want better notification and improvement. Within 3 months of the signing of this agreement, the Public Service Commission will provide a description of the process on its website and provide links to additional information and resources. Training, that there'll be training after the signing of this agreement on what Title VI is for these various agencies. Non-discrimination procedures and safeguards, and in general considerations. Did you hear me mention anything about air pollution? Did you hear me mention anything about whether or not the process by which communities had a right to be in this element were stood up? Whether their fundamental complaints were addressed? Did you hear me say anything about the two fundamental questions that they asked in their complaint? So when Marianne says an alternative dispute resolution process is something that you have no control over, this is a classic example of that. So now, you probably think, I think that this is a really bad outcome, right? It's a bad outcome in terms of the power plant is going to go forward. Is that right, Kamita? Yeah, the Title VI wasn't about that wording. So, but the power plant, which is what they really wanted to be able to cease and desist, is still going to move forward. That's the fundamental issue. But what they were able to do, unfortunately, is not to reduce the environmental burden on their community, but to create a process whereby the Maryland Department of the Environment, the Maryland Department of Natural Resources, the Public Service Commission, and other entities are now going to have to put in place and stand up a civil rights program, an external civil rights program, a process to be in compliance with Title VI for the first time in the history of the state of Maryland. Ever. This is going to happen, right? Now, what takes it from being just a settlement agreement to authorizing legislation? Is a political process that now everyone who cares about this issue is going to have to support the BTB Coalition and the folks in Brandywine as we try and lift up this settlement to make it the law of our state. So this is an alternative dispute resolution settlement agreement. It's a voluntary, informal agreement, And that's what it says all over the document. Informal, 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 right? It doesn't preclude them from having to comply with their other Title VI obligations as stated under the Civil Rights Act of 1964, but it means EPA and the Department of Transportation are going to be watching them as they move this process forward. But the only thing that takes this from being a voluntary agreement is to move forward at a legislative level to make sure that our legislators pass laws and statutes that turn this voluntary agreement into the law of the state of Maryland with authorizing and implementing language. When I tell you that this is not going to be easy, when I tell you that we have a hard time even getting the Maryland legislature to pass statewide law around demolition protocols so people don't deconstruct buildings and structures and spread lead all over the community, that's a battle, right? This is going to be a mother of a battle, but it's an opportunity for everyone in the environmental, civil rights, and social justice community in Maryland to stand behind the Brandywine community to make sure that this doesn't happen to anybody else. So, Kamina, I hope I've done some justice to our conversation about this. It is a big, 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 huge battle. We win some days with EPA, some days we lose. But the point is, you have to keep standing at the barricades. Never sit down and never get up. If you get tired, you tap somebody else in to go forward, right? We fought this externally with the administrator for 9 straight years, and we finally achieved something in the last week of the Obama administration. They fought this for decades in Brandywine. And now we're at a point where we might be able to achieve something, but at the end of the day, we need to have a decision that allows communities to fight back against cumulative impact and to be able to say no about things that harm them and to be able to use civil rights tools in a way that prevent discrimination. Thank you.
All right, well, thanks everybody. Thanks very much to the panelists. We're out of time, so we won't be able to have question and answer. I apologize, but we're here. We're happy to talk further if anyone has questions. And thanks again for coming. Thank you.